For those of you who have already signed in, we should start in about 4 minutes. Welcome, everyone. We're going to get started in about 2 minutes. Welcome, everybody. My name is Suzanne Friday. I'm the Senior Legal Counsel and Vice President of Legal Affairs at the Council on Foundations, and I appreciate everybody dialing in for this webinar. I'm joined by my colleague and our corporate counsel, Justin Aiken, and also Carolyn Nissen from our Knowledge Center. Carolyn's going to go over a couple of housekeeping items before we get this webinar started.
So during the webinar, we will be taking questions. As you can see, if you want to ask a question of the presenters, just click the Q&A icon in the gray webinar navigation bar. You can ask them throughout, but we will get to them during, if we have a chance, or at the end when there is time. At the end of the webinar, you can exit by just clicking the gray in the upper right corner. And there will be a recording available come next week on the website. And also, this is one of 4 in a series in partnership with GuideStar, so be on the lookout for more webinars coming your way.
Okay, thanks, Carolyn. So today our subject, and when we talked with the GuideStar about doing these webinars, we tried to think of some interesting subjects to talk about. We only have an hour today, but we came up for our first webinar here on this topic of risk and liability and insurance. And this is a topic that applies across the board to all foundation types. And as you know, there are lots of different foundation types that can be members of the council. So that's our topic for today. As far as the agenda, I'm going to ground everyone in the governing authority that provides the basis for what we're talking about today. We'll also talk about the role of the board, the unique aspects of a foundation board, legal duties, and then we'll spend the remainder of the time, hopefully about half of this webinar today, we'll be talking about specific instances where boards and foundations can get into liability issues and risk. And then we'll have hopefully have some time at the end for Q&A. As Carolyn said, you can send in your questions. If there's a really relevant question, we'll try and get to it during the presentation, but we'll also set aside some time at the end. So as I said, I want to start right now with a little bit of background on the governing authority when we're talking about issues of risk and liability for foundations. One of the primary sources is your state law, and everybody, depending on what state you're incorporated in, or if you're a trust, what state your trust is formed in, will have individual state law requirements that govern your operations. Many states have nonprofit corporation acts, which lay out all of the specific provisions that govern a nonprofit or a charitable organization. So that's one of the primary areas that we need to be aware of, that you need to be aware of, is what is your state law with respect to the operation and the duties of foundations and the boards that govern those foundations. You also need to be familiar with your articles of incorporation and your bylaws. Both can contain provisions that would subject you to duties and, as a result, potential liability if you fail at those duties. Articles of incorporation are generally publicly filed documents where your bylaws are going to be your internal governance documents. We'll mention bylaws in a couple of places as we go through this webinar today. If you are formed as a trust, hopefully you know if you are, you would have a trust document, a trust instrument, which is likely going to have quite a bit of provisions that will govern your operations. I put in here as number 4 will provisions for testamentary gifts. If you are a foundation that has received contributions or donations as a bequest through someone's will, oftentimes there will be language in the will that have restrictions or conditions associated with that gift. So those are also provisions that you need to be aware of that will govern, in effect, how you use those assets. And again, everything that sets forth a rule or provision about how you operate can in turn lead to liability if you fail to follow the rule or the provision. And then finally, a big area for us at the council, because we generally deal on a national level, is the provisions in the Internal Revenue Code and the Treasury regulations that govern tax-exempt charitable organizations. And as many of you know, there are quite a few sections in the Internal Revenue Code that deal specifically with tax-exempt charitable organizations. There's a whole slew of Treasury regulations that further help define what those laws are. And with all of those, there can be risks and penalties for violating those rules and those laws. There are also other federal laws that you need to be aware of.
An example of another federal law or federal laws that you would need to be aware of, the Department of Labor and Fair Labor Standards Act that applies obviously to all states, and there may be more restrictive laws within your state, but definitely the Department of Labor would be one.
Right, that's a good example. So on this next slide, so we talked about, okay, that's the basis of law and rules and regulations that are going to govern your operations. With respect to compliance with those laws and enforcement of those laws, we often see the state attorney general taking a big role in the enforcement when it comes to charitable organizations. Again, this is state specific, so you need to know what is going on in your state. Some states have a charitable organizations bureau within their Secretary of State's office, and a few states have charitable enforcement in other offices. I think in Florida it's in a different office. In Virginia, I think it's the Department of Agriculture, has the charitable enforcement function. But these state regulators assume this role because, one, they have a consumer protection function. It's their duty to protect the consumers in their state, and donors to charitable organizations can be viewed as consumers. Many states now, I think it's about 43 of the 50 states, have some form of charitable solicitation registration. Again, this is a way for state regulators to know who is out there soliciting contributions, charitable contributions in their state, to have information about those organizations, to make sure those organizations are legitimate, and to take complaints about organizations that may be soliciting when they're not registered, or you know, potentially bogus organizations that are out there trying to solicit. And then finally, these state regulators have the role of representing the public interest. So oftentimes this will come up with enforcement actions. If there's a violation by a charity or an organization in the solicitation rules, for example, under this role of representing the public interest, the state attorney general will be the plaintiff, if you will, in the case. They will take on the role of representing the public in taking action against the charity. And then also on the line of enforcement, we've got the Internal Revenue Service, the EO division, that's the Exempt Organizations Division, that regulates and oversees the federal laws and primarily the tax laws with respect to charitable organizations. As I said before, there's multiple statutes and regulations involved that affect charitable organizations, and many of these have penalties, have financial penalties for violations. So the Internal Revenue Service can enforce those penalties and those regulations and statutes against charitable organizations. And then their ultimate weapon, if you will, and I don't think it's used too often, but they can revoke the exempt status, the charitable tax exempt status of an organization for really serious violations or repeated violations. So as I said, you need to learn or be aware of your state's laws. And when we talk about issues of risk and potential liability for a foundation and for its board, many states do give statutory protections, which help. They're not going to prevent every legal action, but they can help. And they come in many forms. So you're going to want to know what it is in your state that helps to protect you, your organization, and your board. They could be termed Good Samaritan laws, volunteer protection laws. There's volunteer immunity in many states, liability limitations, shield laws, charitable immunity. These are all terms that can be used for these types of laws. There's also a federal law, the Federal Volunteer Protection Act from 1997. And the next slide details some of the provisions in this act. And I'm not going to read this, obviously, word for word. You've got the slide there. but generally it will provide some protection for individuals that are volunteers of nonprofit organizations. It doesn't cover all situations.
Yes, specifically I found interesting on bullet point number 4 here that volunteers are not covered when in the operation of a motor vehicle, vessel, or aircraft. That's a little different than it would be for an employee of an organization. The organization typically would have some liability there if you're in the regular course of your employment. So that's just a particular protection that volunteers do not have.
Right, and many of these types of laws, and you can see, I think it's number 5 on the slide, that there's also exceptions for types of criminal activity. You're not going to get protection if you're engaged in some type of criminal activity. And then also note that this is for volunteers. So if you are a board member of a foundation that's getting compensation, these statutes that apply to volunteers may not serve to protect you. The next slide, I thought I'd include a couple of examples. I found this example from Maryland. Maryland has something called the Maryland Volunteer Service Act, which again you can see provides some liability protection for volunteers. Now this is interesting because it says specifically you're not liable beyond the limits of any personal insurance. So it looks like they want you to use your personal insurance to the extent you can in this situation. The other example I found that I put on one of the slides here is from Pennsylvania. They have, and this is interesting because this is specifically for directors. So those of you who are on the board of directors and not necessarily employees or other volunteers might be interested in this one in Pennsylvania. But this section 5713 provides that there's some liability protection for the directors for failing or breaching duties. If they're acting in good faith, you can see there's an exception for criminal activity and for tax-related issues. So you're not going to be protected in that case, but you do have some protection as a director in Pennsylvania under this law. And as I've already said, it's really important that you know the law in your state and you watch for things like limitations or exclusions. Don't just automatically fall back on your state liability limitation laws because there may be some important exclusions. And as Justin pointed out, the federal act that has the automobile exclusion. In that Pennsylvania example, going back to that one for a minute, it says specifically that your bylaws that are adopted by your members of your nonprofit corporation have to provide for this. So that's also a little important note to keep in mind, that your state statute may actually require that you put it in your bylaws to take advantage of it. And if you don't, if your bylaws are silent with respect to liability or protection from liability, you may find yourself unable to take advantage of your state law. So I'll pause here. Do we have any questions right now, or we're doing all right? Okay. The next slide, so now hopefully everybody's got a bit of background. You understand that there's legal basis for your liability risks, and there are entities out there that can enforce the rules against you. But what I want to talk about right now is what is the role of the board, because as with almost every nonprofit organization and foundations specifically, the board of directors or the board of trustees is the governing body. And so ultimately at the end of the day, if something goes wrong, if there's a claim, there's a legal action, the board is responsible. It may be the actions of certain employees or other volunteers that have caused the problem, but ultimately the board is responsible for the governance of the organization, and therefore the board can be the party that is sued, that is found liable for violations of the laws and the duties. But with respect to the board and the role of the board, these are some of the common roles that the board serves. They determine the mission. They generally will be the ones who select and hire the CEO and also supervise the CEO and perform their performance reviews. The board should, and hopefully all boards out there are involved in organizational planning, usually more of the long-term planning. What's the organization doing? What are our plans to grow? What are our future plans for programs and services? The board should be responsible for determining that there are adequate resources available and oversee the resource management. This usually means the board needs to be involved in the budgeting process and approving the budget, the annual budget for the organization. The board should also monitor the programs and services that the organization provides. It doesn't mean a board should be micromanaging the projects and the services, but the board needs to be aware of what the organization is doing. Lack of information on the board's part is never going to be a defense in any of these actions. It's assumed that the board, by agreeing to serve on the board, that you are willing to be involved and keep aware of what your organization is doing. Other roles of the board: enhancing the organization's public image. In some cases, it's fundraising. Ensure ethical behavior and accountability for your organization, and recruit and orient other new board members, and generally assess the performance of your board and how well you're getting things done on a board level.
So next we're going to get into some board governance, but before I touch on that subject, and I think it's pretty complicated, but we'll try to give an answer.
Okay.
The question is, can you address which state laws prevail when a foundation is incorporated in one state, but volunteers, board members, or the activity occurs in another state?
Wow, that is a great question.
So my answer to this is going back to law school.
Yeah, law school here.
This is essentially a choice of law question, and it would depend on the circumstances. So I'm sorry, that's a lawyer answer. If there was a specific instance of, say, someone being injured or something happening that's going to happen, the choice of law is going to be the state in which that incident occurred. If it's something to do with a board decision, the state law of where the foundation is incorporated would govern. So it is very fact specific on what actually.
Yeah, I think that's right. Yeah. So for instance, if an event is held in state B and someone's injured at the event, the plaintiff is likely going to sue in state B, and the law of state B would likely govern the outcome of that. However, if the claim is against, some kind of general mismanagement by the board, misappropriation of funds or something like that, they're probably going to sue or need to sue in state A, where the foundation is incorporated.
And this is a good reason to plug some corporate law. This is why you should always have choice of law provisions in your contracts, and so it can be stated specifically.
Yes, absolutely.
What state law governs this agreement.
Yeah.
So hopefully that answers your question, Laura. So board governance. First, we'll talk about what is unique about a foundation board. Obviously, a foundation board authorizes grants, and it raises funds to build the foundation's assets. And when giving out grants or any donor agreements, all of that is covered and authorized and handled by the board. And the board is the ultimate governing authority of the organization, not the employees or staff or even the officers. Specifically when dealing with board governance, I like to say when anyone agrees to be on a board, they're agreeing to specifically they are duty of care and duty of loyalty. So I like to look at this as a two-part test essentially, and the duty of loyalty is first. So I describe it as an undivided allegiance to the corporation's best interest. So you must first be loyal. It creates an obligation to refrain from conduct that would injure the corporation. Now, it doesn't mean that you don't have other interests. Clearly, we all have other interests business, personal, or otherwise. But it means that when a conflict arises, you must disclose that conflict to the organization. So making decisions in the best interest of the corporation and not for your personal or economic benefit is, in essence, the duty of loyalty. So once you have your undivided loyalty to the organization, there is then a standard of care in which you must make the decisions. So, and that is the duty of care. So courts generally provide protection to directors, and it's called the business judgment rule. The rule essentially states the courts will not second-guess the judgment of corporate managers as long as the actions were reasonably informed and the decisions were made in good faith, and without the presence of any conflict of interest. So that essentially means there needs to be no ulterior motives for making the decision. The conflict must be disclosed, and the decision must be a reasonable, logical one that you could back up. In that case, the court is not going to essentially hold the directors liable, even if there were negative consequences or it was a bad decision. That doesn't mean that you're personally liable for something. It just means it didn't work out. But as long as it was a reasoned decision, you're all good. And so the next bullet there is good faith, and that's essentially what I've described above. Again, under the duty of care, as long as the decision was made within good faith, then there will be no issues under those two duties. So those are very, very, very important. Next, we have the conflict of interest, and I touched on this a bit under the duty of loyalty, and it depends on the state. So this is a state-specific issue. Some states require that you have a conflict of interest policy. Typically, the council is incorporated under New York law, so the New York Nonprofit Revitalization Act governs our organization, and it says that we need to have a conflict of interest policy. Every state does not explicitly say that, but we believe it to be a best practice. And essentially, you're agreeing to disclose any actual or potential conflicts of interest, or any appearance of a conflict of interest. And at that point, the policy would need to be detailed to tell all the members what the next steps are, whether or not the conflict is voted on at the next board meeting, or whatever the policy the organization wants to come up with. You need to have a policy. We also suggest that all board members fill out a conflict of interest every year, acknowledging their responsibility to disclose conflicts and disclose any conflicts that they hadn't disclosed previously or maybe had forgotten about.
And some states, like New York, now require an annual. It's not so much that you have to sign something annually, but the board members have to provide the organization notice of any potential conflicts or any actual conflicts on an annual basis. So the next bullet point on this slide is really kind of repeating what we've already talked about. With respect to state laws that provide some liability protection, it's important to know whether it applies just to volunteers, whether it can apply to board members that may receive some compensation. That's important, and can also depend on your level of duty. Compensated board members are sometimes treated a little differently than volunteers. Volunteers are often given a little bit more protection, a little bit more leeway in their actions. The bylaw provisions for indemnification, again, similar to that Pennsylvania law that says you need to state it in your bylaws if you're going to protect your board members or provide legal defense for them or indemnify them against claims. Many organizations nowadays have those types of provisions in their bylaws. They spell out specifically that under, according to our bylaws, our organization will provide indemnification for you as a board member in the event of any claims, any personal claims against you personally. We will provide insurance to back up that indemnification, and Justin's going to go into the insurance part of it here in a minute, but very important to know. And if you don't have anything in your bylaws, it might be something that, it's now's the time to consider. Do you need to add something in your bylaws to support your organization indemnifying and protecting your board members. Many board members, when you're looking for new board members, will want to know, do you provide indemnification? Do you provide D&O insurance? It's starting to be a much more common question now for people considering board service. And then the last bullet point, and I apologize to all the private foundation people out there, but this is really specific to community foundations. The council has many, many members that are community foundations, and one of the special rules that apply to community foundations is that the board has something known as the variance power. And the variance power allows the board to modify or change a restriction on assets. Say, for instance, a donor had made a gift to the foundation with certain conditions that it be used to support only a certain organization. Well, all the boards of community foundations have this power, this variance power, where they can, under certain circumstances, modify those conditions, which could be seen as contrary to the original donor intent. But the variance power is actually pretty rare. Instances of using the variance power are pretty rare, and it's a serious thing. And I put this on here because I want to make sure that those of you from community foundations understand that if your board is going to exercise its variance power, this is a decision to take seriously and to really have consider and have the justification and have your reasoning well thought out before you decide to exercise the variance power. It also should be well documented in your board minutes of why you're using the variance power, because this is one of the areas where there could be a complaint, a claim or a question about why you did this. And you need to be able to back it up and justify your decision as a board member, and the decision needs to be made in good faith, considering all of the facts. And normally the board's decision will be respected in that instance.
So next we're going to talk a little bit about director and officer insurance. So to provide a little context and to piggyback off the last slide, Suzanne mentioned that bylaw provisions for indemnification. So indemnification is essentially an organization is indemnifying whoever, in this case, the board of directors, from any claims or actions that arise from their work on behalf of the organization. So that then leads into why you need the insurance, because if any claims come up, it is the organization's duty to protect those people in certain circumstances, and we'll get into that. And before I do get into that, I definitely think we're just touching on this topic as a brief overview. I think all organizations should ensure that they have the proper D&O insurance and that they should consult with their outside counsel and their broker to make sure that all of their liabilities and specific needs are being taken care of by their insurance policy. So the coverage is for organization, directors, trustees, officers in 3 major areas. And specifically it says, this slide says it protects you against actual or wrongful acts. It doesn't necessarily protect you if you are the doer of wrongful acts. That is a specific nuance there. So governance liability, they're from claims arising from general governance decisions made by the board on behalf of the organization. The fiduciary liability, the fiduciary duties are what we discussed before, the duty of loyalty and the duty of care. So claims arising from alleged fraud or improper financial oversight. And employment practices liability, and this could be whether or not they are gender discrimination claims, race discrimination claims, sexual harassment claims. All of those would generally fall under director and officer insurance. And generally they are to cover the personal liability, again, the personal liability of directors and officers as long as they acted within that duty of loyalty and care, and to provide the organization with reimbursement if you have to defend a director or officer in this case.
Right, because otherwise, without insurance, you could still be liable for a claim, and then you're having to dip into your own assets to satisfy the claim.
Yeah, if you provide indemnification, whether or not you have insurance, you're going to have to defend that person or persons. And when trying to decide if the insurance is right for you, or even if you have insurance, whether or not you want to actually make a claim or just handle the defense on your own, sometimes, and this is policy specific, but the insurance company may have the right to select a defense attorney that is used for the defense. They may be able to make decisions regarding the settlement of a case, and that really gets into the heart of the matter. As a client, typically, you have the right to tell your attorney whether or not you want to settle, how you want to proceed in the case, but in the insurance defense, you may not have that right. And the insurance company may want to settle and cut their losses where you may want to continue to fight the case. So that's something to consider. And also, if you want more board control of the situation as a client, that may cost you more money and may add to the policy. So these are all things that you need to go over, again, with in-house or outside counsel and your insurance broker. So the next slide, we suggest you talk to several brokers. So don't just talk to one broker, because some brokers, I'm not speaking ill of insurance brokers, but they may just have a general coverage that they provide to organizations, but that may not be specifically what you need and may not address all your concerns. So in addition to knowing, because I assume a lot of you have current policies, and in addition to knowing what your policy covers you for now, you may want to do an internal or have an internal discussion about what you want to have protected or where you think you have particular liability that you need coverage, and ask your broker or insurance company to add that coverage.
Okay, so we're right on time here. We're about halfway through, which is what I was hoping for.
We have some questions.
Oh, we have some questions. You want to look at the questions real quick? I'm going to take a pause to look at the questions.
So the first question is, we often receive requests from universities asking to remove the indemnification language. How do you advise we respond?
The indemnification language in a grant?
Doesn't say, maybe in a grant agreement or some sort of agreement with a university. So in general.
Yeah, no, I think I've had this in my former life. I worked for a large nonprofit, and we did a lot of work with universities, grant related.
Yes, in a grant agreement.
Yeah, and there would be provisions that say the university, if they're going to do work for us or perform under a grant, they have to indemnify us for anything that might go wrong. They might have to indemnify the organization who's providing the money. They're doing the work, and the university would say, a common response was, well, we just can't do that. We're a state university. It's against state law that we provide indemnification for you. And it's really a matter of negotiating. If that is in fact the case, a lot of times we would modify the agreement to say, you'll indemnify us to the extent allowable under law. That's kind of a little workaround to say, if the law says you can't indemnify us, well then, we won't hold you to it. But if you can, we want you to indemnify us. So just like if you hire a contractor and they do something terribly wrong, you want to hold that person responsible who's doing the work. So hopefully that.
Yeah, I think that answers the question. And my general thought is I handle contracts for the organization. I rarely sign a contract that does not include indemnification language, whether it's a grant agreement with a vendor, a contractor, anyone. I have an indemnification clause. The way I typically get around someone wanting to take it out is say, let's just make it mutual. So we're both indemnifying the other party for anything that we do wrong. Some people like to use the term gross negligence, so it's just not every act of negligence. I don't like to use gross negligence when they're indemnifying us. I like to use regular negligence. But mutual indemnification typically gets around that unless, like Suzanne said, there is some state law provision. I would be careful because I think those provisions are they're very limited. So it doesn't allow them to get out of any indemnification, but they will tell you that. So that's where I think having an attorney that knows your state law is very important.
Exactly.
So I would counsel with an attorney before you just let them off the hook from any indemnification at all. Yeah. We have another question about D&O. Let's see. I have been told that not all D&O policies include employment law coverage, and also that sexual misconduct is an add-on and not in the typical policy. Any comment?
Yeah, no, that's a really, really good point. That I think we're getting more to kind of a menu of choosing the coverage that you want and what you need. That sexual misconduct is an area that has grown, and so there are insurance companies and brokers and policies that may try and exclude exclude that or add on additional cost if you're going to have that coverage. Another area that comes to mind is additional coverage. Sometimes the insurance company will require additional cost for additional coverage for individual employees or officers that are handling large amounts of money. You know, you might need a special bond or something for that to cover that individual who's got the ability to make transactions and handle the bank account of the organization, specifically where large amounts of money are involved, and that can be an additional coverage that you have to pay additional for. So it really does require good communication with your broker and knowledge of what you're buying and what you're paying for.
Yeah, and these policies are not one size fits all. So I would, and even when dealing with the broker, you can tell them what you want, but there will be exceptions even when you have coverage. So I think I always counsel people that you should have an independent party of that transaction review the insurance policy because they are long. But to understand, even when you do have coverage, what exceptions there are to that coverage or what limitations there are to that coverage. But this is a good question to go to our point of, if you know that particularly you have an organization in which has had some employment issues in the past, you know you want to beef up your insurance there, you need to make sure that you understand the policy and ask for that. So it's very important that you understand your policies and, again, all the exceptions to the coverage that your policy grants you.
And it works both ways, too. I mean, if you're a small family foundation where you have no employees, you know, the family is managing the foundation purely on a volunteer basis. You don't want to be sold and paid for expensive employee type coverage. So, you know, it can go both ways. Are we good with the questions?
Yes.
Okay. So the next half of this webinar, what I wanted to do, in thinking about how we were going to present all this, is so it's one thing to understand, you know, yeah, there are these laws out there that we have to comply with. Our board has a duty to act in a certain way. But how does this play out in real life? Give me some real life situations here where there could be a risky situation, a potential for liability. And that's what I kind of rack my brain to think of what the most common things that I'm hearing here at the council from our members are potential liability issues. And this is not meant to be a completely exhaustive list, but these are popular topics that keep coming up where there are some risks to the organization. Donor-initiated fundraising, fiscal sponsorships, and 990 reporting and audit responsibilities. I'm going to cover that. Justin's going to take some of the other ones. So we're going to start with this donor-initiated fundraising. And again, this is something that's really going to be much more applicable to the community foundations that are on the webinar today. But as you all know, community foundations hold a variety of funds that include contributions from many donors. Some donors, especially in the area of donor-advised funds, want to fundraise for their fund. They want to grow their fund at the community foundation. They want to have events or different activities to raise funds for the fund they have there. But this can certainly raise some risks for the organization, for the community foundation. If your donor is out there soliciting contributions and acting as an agent for your foundation, you need to know that, and you need to be okay with that, and they need to know the boundaries of what they can say and what they can do. There are charitable solicitation laws, as we mentioned already, in many states, and it is very, very important to, if someone is out soliciting contributions, which ultimately come to your community foundation, that they are properly representing who they are and what they're raising money for. And because if they're not, if they're misrepresentations, even if it's innocent, if there's no bad intent involved, but they're just not explaining that they truly represent the community foundation, it could be a violation of the state charitable solicitation law. And so there you have some risk, there you have potential liability for a violation and possibly a penalty. Fundraising events always present risks and potential liability. So if you are going to allow your donors that have funds at the Community Foundation to hold events, fundraising events, you need to know about it. You need to be very clued into what type of event it is, because ultimately you could be held responsible for any accident or injury or something that happens at the event. A plaintiff, an individual who gets injured at an event, is not going to stop at suing, the donor who was hosting the event, but they're going to name the Community Foundation as well, 99% of the time. And then I've got on there grant applications and responsibility for grant funds. If your donors, and I've seen this happen, donors want to raise money for their individual funds, they apply for grants without the Community Foundation's knowledge. And a grant, and applying for a grant and receiving a grant is an obligation then to perform and oftentimes to complete certain work in return for the grant money. And if that's not happening, again, the Community Foundation can be held liable for refund of the grant money or performance under the grant. So absolutely, if you're going to allow any of your donors to do this, you need to know exactly what they're doing. And all of this can be dealt with by drafting and adopting a policy, an internal policy that you would have for your Community Foundation on when and how donors can do donor-initiated fundraising activities. And you can spell out all the parameters, make sure that they know they have to notify you well ahead of time. You have to get your board approval of the activity. All those things should be put in a policy that's given to the donor well ahead of time, so the donor knows the limitations of how they can do donor-initiated fundraising. I also want to say that it's perfectly okay if your policy says we just won't allow donor-initiated fundraising. If you're a small organization or you're concerned about the risk, there's nothing wrong with making it your policy right now to not allow donor-initiated fundraising. The second area where I get a lot of calls on, and I see opportunity for risk and liability, are the fiscal sponsorships. And this is really similar, I think, sometimes to the donor-initiated fundraising, in that you as a community foundation are offering to be the fiscal sponsor for a group of people, another organization that doesn't have their own legal status, or an individual that wants to do something charitable. They want to engage in a project or something charitable, but they can't do it themselves because they don't have their own charitable status. So you as the community foundation assume the fiscal sponsorship of that project. By doing so, you also assume the responsibility for the project, for ensuring that distributions from the money raised actually goes to the charitable purpose, for contracts and payments to vendors and consultants that are needed to carry out the project, and for the accounting and the reporting of all the contributions that come in. So you're taking on quite a lot of responsibility, and you need to be aware of exactly all the details of the project. There needs to be a very clear understanding and in writing between the community foundation and the individuals who have the idea for the project of how this fiscal sponsorship is going to work. And if you're not comfortable with your ability to completely oversee everything, then maybe it's not the right activity to get into.
We have a question
that's
related to so the agent foundation.
Okay.
So the question is, does the agent foundation also apply to other 501c3 organizations who are raising money for their endowment funds? Is that also a risk to the foundation?
Yeah, I think I understand the question.
Does that issue apply to other 501c3?
Right. So you have an agency that is a legal entity and a charity in its own right that has a fund at the community foundation. The agency is raising money And any money that the agency collects directly to the agency, I don't think the community foundation would normally be involved or be held responsible for something that the agency does as far as a fundraising event or a solicitation, if the money is coming straight to the agency. And then if the agency collects all the donations and turns that over to the community foundation at a later point, that's fine. It's when the agency is out there holding an event or a solicitation and are telling people, make your gift directly to the community foundation, that you can run into problems. That in that way, then it does seem like the agency is merely just a fundraising agent for the community foundation, because they are telling people, give your donation to the community foundation. It's going to go in the agency's fund, but the donation is to the community foundation. So, you know, a plaintiff, that someone that was injured or something that happened at an event, is going to probably sue all parties involved. And it's going to be up to the community foundation to try and get themselves out of the lawsuit. You know, the agency may say that we were acting merely as an agent for the community foundation and we're not responsible. There's all kinds of legal, you know, arguments and defenses that you can get into. But yes, I think bottom line for the question is that even another legal entity could be viewed as an agent if they're out there soliciting and telling people to make contributions to another organization, to a community foundation.
All right, we have more questions. They're
popping. More questions, oh boy.
All right. This is another one for you.
Okay.
How does a fiscal sponsorship differ from a field of interest fund targeting a specific project and that makes grants to non-501c3s to pay expenses related to the charitable project? So I guess, how is a fiscal sponsorship different from a field of interest fund?
Yeah, you know, in reality, they can seem very, very, very similar. So I understand the question. It's more about the original intent of the parties. Personally, I like to keep fiscal sponsorships to limited time period projects. In my mind, that is what works best, is if you have a group of people that have a specific goal in mind, a charitable project, whether it's to build the dog park or you know, something like that. It's going to be a limited time period. They're going to raise money. They're asking you to collect the donations. The community foundation can give the donors a tax deduction. The community foundation then holds the money and pays the bills necessary to carry out the project. That to me is really the essence of a fiscal sponsorship. A field of interest fund, if it's limited to a very specific project, I think you're really kind of talking about a fiscal sponsorship. Field of interest funds, in my mind, are much more broad. You know, it's your arts fund, it's your healthcare fund, it's your education fund, and the field of interest fund collects donations, similar to the fiscal sponsorship, gives donors the tax deduction, but then more often will be making grants to other organizations versus paying vendors and paying invoices for work to be completed. But it's very easy to get those two intertwined. And you know, if you wanted to send me a message later, or if you want to continue that conversation, I'm more than happy to talk about the individual facts and what your situation really looks like.
Okay, along that line, and you may have answered this as I was reading the question, but what responsibilities do a private foundation have when making a donation through a fiscal sponsor? Should they be going and doing due diligence that the fiscal sponsor is conducting appropriate activities and reporting with non-501c3 grantees?
Yeah, and that's a great question. Technically, if the fiscal sponsor is a 501c3 public charity, and you make a grant to that 501c3 public charity, and even if it is for a specific project or a fund, you really don't need to do anything more. you can assume, based on their status as a 501c3 public charity, that they are going to use your grant money properly. And so really for you as the private foundation who's funding this, your responsibility stops there. Now that's certainly not to say that you can't ask for more. You can't decide to perform additional due diligence and find out what's happening with the project, how's the progress going, can I be sure my dollars are being spent on the right kind of things. That's more of a relationship building with the community foundation or with the sponsor, the fiscal sponsor. But technically, legally, you don't really have a responsibility to do any more due diligence than you're making a grant to a public charity. We're down to about 10 minutes, so we're going to try and get through the rest of this pretty quickly, and if we have any extra time, we'll go back to the questions. But another area, and I'll go over this really quickly, is for potential risk, for potential liability, is in the area of your 990 reporting and your audits. Bottom line here is that the board needs to be aware of what's in the 990s, what's in the audits. They need to be aware of the financial situation of the organization. And in fact, on the IRS Form 990 at Part 6B, there's actually a question that says, has the organization provided a copy of the 990 to all the members of its governing body? So hopefully everyone can answer yes to that, but that is very important because lack of knowledge, again, is not going to be a defense if there's a problem. The next few items are other potential liability areas. I think Justin's going to go through these really quickly. Which one? Oh, real estate. I'm sorry. I'm going to talk about real estate. Yeah, real estate and other property. This is for those of you who own any property, whether it's an office building or recreational property, athletic facilities, whatever. You know that there are risks and potential liabilities involved, different areas, premises liability, landlord-tenant, all of those things could pose potential liability, and that's another reason why you want to be knowledgeable about what your insurance policy covers. If you do need to get additional coverage, if your normal D&O policy doesn't cover, accidents on real estate, you need to ask your broker, what does it take to get that type of coverage? Okay, now we'll go to Justin.
All right, I'll go through these fairly quickly. So as the slide says, 94% of claims of these employment law claims are covered under director and officer policies. But again, you need to read your policy and make sure. But some of those things would be sexual harassment, racial and gender and age discrimination, retaliation against whistleblowers. I'll touch on that more in a second. Defamation, failure to accommodate under the Americans with Disabilities Act, and improper employment classification. And really quickly, the Department of Labor is undergoing a proposed rule change to the Fair Labor Standards Act. And you can email me about this more because this is pretty involved. But essentially, the salary test is changing. The salary is almost doubling for those to be exempt from the overtime wage law. So essentially, if you have someone making, I believe it's about $24,000 right now, and we believe it's going to go up to about $50,000. So someone who is currently making $40,000 who is exempt, meaning you are not paying them overtime after 40 hours of work, will now be non-exempt and will need to be paid overtime if they work beyond 40 hours. So that is going to change a lot for not only foundations, but publicly held, publicly traded companies, all sorts of organizations. So that's something that you need to definitely consult with an employment law attorney about, and specifically for your state, because your state can be more restrictive than the Fair Labor Standards Act. But you should also have an employee handbook that covers all of these topics above. They also, an employee handbook will cover vacation time, sick time, all of those issues. But I can talk about that more if you have a question. Whistleblower policy, you should definitely have one of these. Now, a whistleblower policy is something that is governed or is required by state law, but is typically going to be governed by federal law. The purpose of a whistleblower policy is to protect individuals who see any illegal activities or anything, what am I trying to say? Anything that needs to be reported to someone above them in the organization, they need to be protected against retaliation. That retaliation is what I mean by that will be governed by federal law. If someone makes a sexual harassment claim, we don't want them to be retaliated against. And if you do retaliate against them, and if there's an EEOC investigation going on, that could be seen as some criminal liability because that is a federal investigation. Or if you have an IRS investigation going on because someone said something about some financial impropriety that they believe to be going on, that's a federal investigation. So you cannot be, to our second bullet of record retention, you cannot be destroying any documents or falsifying any documents to get around or impede that investigation. Those do have criminal liabilities, and you should consult with your attorney about that, not about the crime you committed, about not committing a crime.
and I just want to make a note, again, for the community foundations out there, that if any of you community foundations have done the national standards for community foundations and have received your national standards accreditation, you are probably well familiar with the whistleblower policy and the record retention policy. These are things that are required for national standards. The national standards folks review them carefully and are looking for things like, the no retaliation clause in the whistleblower policy and the legal hold clause, which prevents you from destroying documents if there's a legal claim under record retention policy. So you guys should know about that if you've done national standards.
Okay, so we have a few minutes. I've sent this message to a few people who've asked questions, but Carolyn will be placing the slides on the website for everyone to view. If for some reason you can't access the website, please email either Suzanne or myself, and we will make sure that you receive the slides. But I'll try to get to a few of these questions here. First question: Do you feel social media liability insurance is necessary for private foundations? This is interesting. I don't. So I'm going to say I don't know if there's insurance, and I guess you're asking if there are if someone is punished for anything they do on social media. First, I think you should have a social media policy within your employee handbook. I advise organizations when I was in private practice, but I recently went to a CLE, and I think that organizations, if they want their employees to have a social media presence, should have a separate account for work from personal. So you should not ask somebody to tweet or make a post on Facebook or on Instagram from your organization through their personal account. Because if they then post something that you don't like, you shouldn't be asking them to take that down. That would be a First Amendment law issue. It's really complicated. Essentially, don't tell anyone what they can or cannot say on social media. I don't know that you would need insurance for that. I think you should consult with your employment attorney if someone does something or says something defamatory or slanderous, in which you will then be punishing them for that. So I would consult with the employer.
But it does go back to kind of the premise of this whole webinar, is that the board of the foundation is the ultimate governing authority, and they are, assumed to be responsible and know what's going on, including what employees are doing. So if employees are out there doing something representing the foundation, yeah, I think there could be some liability to the board for if an employee were, again, they would have to be representing the foundation, saying something defamatory or whatever. I think the organization could get sued, right?
Yeah, and this is why I think you should have an employee handbook, because you can violate sections of the handbook through social media. So say someone posted some confidential information, they can be reprimanded for that, but you need to have them on notice through your policy. So this is why it's important to have these policies in place beforehand, so then when the situation arises, you don't have to scramble to figure out what you're going to do. You just implement the policies that you already have.
Yeah. All right. Well, we've reached 3 o'clock. Do we have a lot more questions, or?
We do have a few more questions, but I'm trying to get anyone who has asked a question that hasn't been answered, I will be sending you a message on here to get in contact. And
yeah, we'll answer your questions. We'll definitely answer all the questions.
Yeah.
Okay. So thank you, everyone, so much for joining us today. And again, this is the first of 4 in a series that we're doing with GuideStar, so be on the lookout for our next one, which I think is going to be in January, right? Yep. Okay. Thank you.